Hello everyone, my name is Mohammad Nadeem and I teach law in University of Delhi. Today in this video, I'm going to discuss the topic plea bargaining. Plea bargaining is given under chapter 21A of CRPC. Initially in CRPC, this topic was not there. So this is some sort of new topic that has been inserted in CRPC in 2006. So in this video, we will discuss the concept of plea bargaining, the types of plea bargaining, and why we need plea bargaining and what are the disadvantages of plea bargaining, and later on we will discuss the procedure of plea bargaining which is given in CRPC. Okay, so what is plea bargaining? Basically, plea bargaining is a pre-trial negotiation between the accused and the prosecution or the complainant. Here, the prosecution says to the accused that if you plead guilty, then you will get a benefit. And what is that benefit? That you will be given lesser sentence. So, it is an agreement. It is an agreement or negotiation between the accused and the prosecution or the complainant that if you plead guilty, that if you accept the charges against you, then in return you will get some benefit, and that benefit is that you would be given a lesser sentence. Okay. Now, there are three types of plea bargaining. The first is charge bargaining. What is charge bargaining? In charge bargaining, when the accused pleads guilty, there is an agreement and negotiation, and in that negotiation, the accused pleads guilty that yes, I am accepting these charges against me, but what will I get in return? So the prosecution says that if you plead guilty, then certain charges, few charges would be dropped against you. If there are like 4-5 charges, so amongst them 3 charges would be dropped, or 2 charges would be dropped, or some serious charges would be dropped against you, and you will only be convicted for few charges or for lesser charges. The second one is sentence bargaining. mental torture. Most of the cases are fake cases. So, mental torture is there in fake cases. Even if the case is not fake, the process of trial is very lengthy in India. There are cases for last 30 years they are pending, 20 years, 10 years. So, avoiding mental torture of the accused, coming to the court, he is not able to do anything. Mental torture is there now when you have any charge on you. So, you have mental torture. So, this lengthy process will increase the mental torture. Okay? So, if you plead guilty, then you can do it before trial starts and you won't have any mental torture. So, to avoid mental torture as well, this plea bargaining concept will work. Third point is avoiding legal expenses. Means accused will hire a lawyer and the other side will have a prosecution in case of when the cases are on police report, there is prosecution, or if the case is of complaint case, then in that case the other party will hire his lawyer or her lawyer. So there is legal expenses from both the side, the prosecution and the accused. If there is prosecution, then there would be government expenses and the accused will have to hire a lawyer. So both the parties will have to incur huge expenses on litigation. So to avoid that, plea bargaining is a concept that must be introduced in CRPC as per Law Commission. The fourth point is congestion in jails. We have lesser jails, spaces are very less, the conditions of jails are already very poor. So to avoid congestions, if we put every person behind bars or in jails, so there would be too much crowd in the jails. To avoid that congestion or crowd in jail, we should have this plea bargaining concept in CRPC as per Law Commission, right? Fifth point is under trials exposure to hardcore criminals. It means that if you have done a very minor offense, so in that case you will be arrested even if it is a very minor offense and you will be put in jail. In jail, there are various hardcore criminals as well, lifers, for example, who had attempted rapes, who have committed murders, etc. So those who are there in the jails for very long time, they are hardcore criminals. So you will mix up with them. For example, you have done a very lighter offense, you will also be put into the jail, and there are other hardcore criminals as well. So there you would be friended with them, you will have an exposure to them. So there are chances that once you mix up with the hardcore criminals, then you will become a hardcore criminal, or there are chances of committing more crimes on your behalf. Now, the disadvantages of plea bargaining. Like everything has advantages, similarly they have disadvantages as well. So the first disadvantage is that right of fair trial is removed. Every accused or under trial has a right to have a trial. He be convicted or acquitted through fair trial. But once you accept your offense or once you plead guilty, in that case your right to fair trial is removed. That you are not being convicted through a fair trial, but you are accepting it on your own. So this is removed, right to fair trial. Second is no appeal. In cases of plea bargaining, there is no appeal. It is also given in chapter 21A that there is no appeal as per section 375 of CRPC. In case of plea bargaining, there is no appeal. So when there is no appeal, so it is very difficult. So that you are convicted, you have given punishment, but you cannot appeal in that case. So this is also the disadvantage. You don't have appeal, but you have writ petition under 226 and 227 to the High Court and special leave petition. Third is possibility of coercion. Possibility of coercion means that prosecution may coerce you or court may coerce you. Okay? So there is possibility of coercion that you may be pressurized to plead guilty in return of some concession. So there is possibility of consent, which is also the disadvantage of the plea bargaining. So now we will discuss the steps involved in plea bargaining in CRPC. So the first step is, it is given under 265A to 265L in chapter 21A of CRPC. So the first thing is application of the chapter. It means on which offences this chapter applies, means the cases in which you can do plea bargaining. So in 265A it is given that the offences in which punishment is more than 7 years, or the punishment is life imprisonment, or the punishment is death. In these cases, you cannot take benefit of plea bargaining, or you cannot do plea bargaining. So plea bargaining is only and only in the cases in which the punishment is up to 7 years, right? But there are other provisions as well. The offences which are against women, or the offences which are against the child below 14 years, or the offences which are socio-economic offences. In those, you cannot do plead bargaining. For example, first of all, it says that you can do plea bargaining in offences, the punishment for which is up to 7 years. But for example, it is the case of voyeurism, which is given in section 354C. But punishment for that is, for example, on first conviction, it is like 1 to 3 years. So the punishment is less than 7 years. So you can say that because it is the case in which the punishment is less than 7 years, so we can do plea bargaining. But you cannot do plea bargaining because it is clarified in the provision that even though the punishment is less than 7 years, but if it is against a woman or a child below 14 years, or the socio-economic offences, in that case, even if the punishment is less than 7 years, you cannot do plea bargaining. And now what are the offences which are socio-economic offences? There is a list which is given in second subsection, which, for example, socio-economic offences is against Navy, Indian Army, or is it domestic violence, or Sati Act, or immoral traffic of women, indecent representation of women, metro rail, related to metro rail, or food products. So these are, or explosive or cinematography act. The offences which are under these acts, these are called socio-economic offences. And this is not the exhaustive list. From time to time, it is also given in this section that central government has power to declare a particular offence to be as socio-economic offences from time to time. So for the time being, we have this list, but this is not exhaustive. Central government has power to add on certain other offences or acts to be called as socio-economic offences or socio-economic acts, and after that we cannot do plea bargaining on those acts or offences. Second part is 265B. It says application for plea bargaining. Application means who will file application. So it is only and only the prerogative of the accused. Accused will only out of his sweet will or voluntarily file an application in the court where the trial is pending. It is not the prosecution or it is not the victim who will file application for plea bargaining. It is only and only the accused who will file the application for plea bargaining, and in which court, in which the trial is pending for that particular offence. Along with application, he will file an affidavit in which he will so on that he had understood the nature of the punishment, and he has understood the plea, and that he had never before done the similar offence. For example, theft. So he has never done theft before. if you are doing plea bargaining, or if you are applying for plea bargaining in an offense which you have done before as well, in that case you cannot do plea bargaining, because if you are doing it again, then you cannot take benefit of plea bargaining. And in application you will also mention the offense and a brief description of the case. After filing application, the court will fix a date, will send the notice to the prosecutor if the case is on police report, and to the complainant or victim if it is a complaint case. So it will send a notice to those parties and will fix a date for hearing. Then when all those parties will appear on the date so fixed by the court, then accused will be, there would be in camera proceeding of accused, in which judge will ask or judge will see whether the accused has applied for plea bargaining voluntarily or involuntarily. If the court finds that the application by the accused has been given voluntarily, then it will proceed and will fix date for mutually satisfactory disposition between the prosecutor or the accused, or the complainant or victim or the accused. In that, the court may ask to give compensation to the victim or any other expenses that has been incurred till now by the complainant or the victim. Now, but what if the court finds that the application was filed by the accused involuntarily, or in pressure, or somebody has coerced the accused to accept the plead guilty? So in that case, the application won't be accepted by the court and the proceedings will be started again from the point when the application was given to the court. Okay. Now, for example, the accused has applied given this application or wants to plead guilty voluntarily. Then we will proceed here. Then there would be mutually satisfactory disposition of the case, in which parties will sit together and they will decide the quantum of compensation to be given to the victim. So the guidelines for mutually satisfactory disposition given under 265C, it is the duty of the court throughout the process of mutually satisfactory disposition, means they will be asked to sit outside the court anywhere, for example in mediation center, in courts. So who will sit, who will participate in that mutually satisfactory disposition of the case, and what all can be given. So in that, if the case is of police report, in that case the public prosecutor, number one, number second the police who has investigated the case, the victim and the accused. And if accused wants, that he can also engage his pleader in this mutually satisfactory disposition, right? And if the case is of complaint case, in that case the complainant and the accused, and if both of them wants their pleaders to sit together or engage in this process, so they can allow them to sit as well for mutually satisfactory disposition. And throughout the process of this mutually satisfactory disposition, court has to ensure, it is the duty of the court to ensure that the whole process is done voluntarily with the will or the wish of the parties. It should not be against the wish of any party. For example, I am saying you accept 1 lakh as compensation, but the victim is saying I want 1.5 lakh or 2 lakh for compensation. So here both parties are not having any mutual agreement on that, so that won't work. Now 265E, this is very important. This only tells us that we have only sentence bargaining. This is the main point in this chapter. 260, sorry, before that we have to do 265D, report of mutually satisfactory disposition to be submitted before court. Now you had a mutual satisfaction here, right? Then after that, what has been decided in that mutual satisfactory disposition, the court will prepare the report of that in court when you will be presented in the court on next hearing. So the presiding officer will prepare a report that what all has worked out between you, means both the parties, the accused and the victim, and the presiding officer will sign on that. And who all will sign? All the parties who took part in the disposition. So all of them will sign on that. And if it did not work, there was no mutual satisfaction, then in that case court will start proceedings from the stage when the application was filed in court for plea bargaining. Now in case it has worked out, means there is a mutual disposition, there is mutual satisfactory disposition, then compensation would be given as per this. Now coming to the part of sentencing, 265A part A says that compensation would be awarded by the court that has been decided between the accused and the victim. Second point, the hearing of sentence, means compensation has been given, expenses have been given. Now let's come to the sentencing part, means this was the only thing now for plea bargaining, means you will be given lesser sentence. It does not mean that you will not be given any sentence. It means that you plead guilty and you will be given lesser sentence. So lesser sentence is given in this part 265E. So now compensation given to you. Now the court will hear you on sentence. If court finds that the accused can be set free or can take the benefit of section 360, means if we can leave him on admonition or on probation under 360 CRPC or under Probation of Offenders Act, then the accused will be given benefit of that. If not, if he is not eligible for that, because there are certain eligibilities, certain conditions under 360 CRPC for probation and also in Probation of Offenders Act. So if he is not falling in any of the provision like 360 or the act, then punishment would be given to that, sentence would be given to that. And how the sentence would be given? First part of sentence says that if an offense has been, if the minimum punishment for the offense is given, for example, in certain offenses the punishment is like shall not be punished less than 3 years, but which may be extended up to 5 years. So if minimum punishment of the offense is given, say for example 1 year, not less than 1 year or not less than 3 years, so in that case half of the punishment, the minimum punishment provided for the offense, for example half punishment, for example the minimum punishment for the offense was 1 year and the maximum was 1 year, fine. So if it is 1 year, the minimum is this, which may be extended to that. So in that case minimum, the half of the minimum would be given. If in any offense minimum is provided, then half of the minimum, and half of 1 year is 6 months. Now the accused would be given the sentence of 6 months. So now he is getting benefit now, because earlier if through trial he might have been convicted for this 1 year or more, but here he will only be punished for 6 months. Now he is getting lesser punishment than given for the offense. Another part of punishment says if no minimum is given but maximum is given, then for example in theft there is punishment of 3 years. There is no minimum, nothing. It's just like there is 3 years. So this is the maximum. You cannot punish anyone who is convicted under 379 for theft for more than 3 years. So this is the maximum provided, or in certain offences it is provided as which may be extended to. So in this case, where no minimum is provided but only maximum is provided, here we will give 1/4 of the maximum, right? Means 3 years, 36 months, then it would be 9 months. If you would not have pleaded guilty, then trial would have been there and the maximum punishment would have been given up to 3 years depending. But now here this is sure that you will only be given 9 months, not more than that, right? Now 265F, judgment of the court. The judgment of the court will be delivered in open court. Open court means where public has access generally, and it would be signed by the presiding officer. 265G says that we have discussed in demerits as well. Finality of the judgment means the judgment given by the court in plea bargaining is final. Final means there is no appeal. You cannot go in appeal to High Court or Supreme Court. The only remedy that you have is that you can file special leave petition under Article 136, and also you can prefer a writ petition to the High Court under 226 and 227 of Article of Constitution, right? Now comes 265H. 265H is powers of the court in plea bargaining. It is very simple that what all powers do or does the court have in plea bargaining. It has all other powers that it has in normal trial. For example, power to give bail, or for power to have a trial, etc. So it has all other powers that it has in normal cases or normal trial. Now 265I. 265I, period of detention undergone by accused. Alright. It says that if you committed a case, for example, and the punishment for that was 3 years, right? Now you are in jail, okay, you have been arrested and you have been put in jail, you have not been given bail till now. After 3 months you were given bail. So you have already gone 3 years. For example, in case of this, that you stole something, you have charges of, you were having charge of 377 on you. You were arrested and you were put in jail and you were given bail after 3 months. Now, after that, when you came out and trial was not started, so before trial started, you pleaded guilty in exchange for lesser sentence or punishment. So now the maximum punishment that can be awarded to you is this 9 months, because the maximum is 3 years, and when maximum is provided, in that case the punishment would be given 1/4 of the maximum, that is 9 months. And now you have already gone 3 months in jail or detention. 3 months would be reduced or deducted from here. Then remaining 6 months. Now you have to undergo detention for next 6 months. Means the period that have already been gone in detention would be reduced from this sentence. For example, if you have been in jail for all 9 months, then -9 means now you need not to go to jail. Alright. Now 265J savings says any provision which is inconsistent with this chapter in CRPC, that would not prevail. What will prevail means this is special provision, this is special chapter. If anything in any provision in CRPC is given that you cannot do plea bargaining, that would not prevail. What would prevail? That you can do plea bargaining if it falls in these offenses that we have discussed in 265A, right? So this is special, not general. Now 265K, statement of accused not to be used. This is very important. For example, you are charged with a very lesser offense and you are, you want to go abroad. For example, X charged with a certain offense for the punishment for which is 6 months only, and you have to go outside. Then what you will think? You will think, okay, fine, I will plead guilty and I will get lesser sentence, and then at least I will be out of this process of the court coming and going back to the court. So here you will say, okay, fine, I plead guilty, even though you haven't done that offense. There are two types of people, na? For example, you might have done that, you might have not done that. But for those who might have not done that, but they want to take benefit of plea bargaining to be out of this whole process of the trial and all, and for example, they have some, to be out of the mental torture, or they have some other thing. For example, they want to go to the abroad. It's just an example, right? So they will plead guilty and they will take benefit of it. Okay, fine, 6 months, and if it is the maximum, then 1/4 of it will be given, and it would be 1.5 months, 45 days, and then we will be free. So let's do this thing. Let's plead guilty and let's be out of this process of trial. So in this case, if you are pleading guilty, so your statement that I plead guilty will not be used anywhere except this chapter for this particular offense for pleading guilty. I plead guilty of theft, for example. Now, you have given this statement. In return, you will be given lesser punishment, but this statement of yours will not be used for any other purpose except for this chapter. Or if you plead guilty in exchange for lesser punishment, but this mutually satisfactory disposition did not work out, then what does this mean? That now you have pleaded guilty? No. It will start from that particular, from where you filed an application, and the complete trial would be held. It does not mean that you have pleaded guilty. Why you pleaded guilty at that time? You pleaded guilty just because you wanted to take benefit of plea bargaining, you wanted lesser sentence. That's why maybe you did that offense or you did not do that offense. So this will not be used anywhere except for this purpose. 265L says application of plea bargaining, means it says where it is non-application, where it is not applied. It is not applied in cases of juveniles. For example, if the offender or the accused is a juvenile, so a juvenile cannot plead guilty and ask for lesser sentence, because juveniles are covered under Juvenile Justice Act. Under section 2K, it is given that those who are below 18 years are juveniles. So juveniles have different law, that is Juvenile Justice Act. So they cannot plead guilty and take the benefit of plea bargaining. So it is for their benefit only, for the benefit of the juveniles, right? So I have discussed every stage, the benefits, merits or demerits, and types of plea bargaining. And if you have any query, then you can write in the comments, and thank you so much for watching this video.